Yes, Mr. Thomas.
My lord, my ladies, I intend to deal in the same order as Mr. Metzer with the three questions highlighted by Lord Justice Stuart Smith in his warrant of permission, and then turn to the merits of the appeal. But before I do so, I would like to deal with the assertion that the case of Berry Piling was soundly reasoned. Because when one looks at the judgment, the law in relation to reckless falsity, and I'll use that term a lot, reckless falsity, has been created without any reference to any previous authority, and is simply an interpretation of the civil procedure rules, without any reference, as my lord picked up earlier, to the specific judgment of the Court of Appeal in KJM Superbikes. In my submission, it was not soundly reasoned, and what's more, the comments on reckless falsity are overtone. I know the court has been taken to the authority on a number of occasions, but I would ask, please, that we go to page 237 of the authority bundle, which is the first page of the judgment in Berry Piling.
Yes.
On that first page, you can see the relevant civil procedure rule, which is 32.14, 32.14. And proceedings for contempt of court may be brought against a person if he makes or causes to be made a false statement in a document verified by a statement of truth without an honest belief in its truth. And there has been some amendment to that rule. However, as set out in my skeleton argument at paragraph 6.2, the relevant section of the wording, without an honest belief in its truth, has been contained within that civil procedure rule since its inception and remains in the CPR today. The question for this court is whether, without an honest belief in its truth, encompasses this concept of reckless falsity. Because there is no authority for this position prior to Berry Piling. And this court, of course, is more senior than that in which Mr Justice Ackenhead was sitting.
Yes, we know that.
Now,
at the time of Berry Piling, the rule was 32.14. You've shown us that. What is it now?
It is 32.14.
It is still, right, and still has the same wording.
The relevant part, without an honest belief in its truth, remains the same.
Okay.
It would be, and I've pondered this whilst preparing for this, it would be somewhat straightforward, or more straightforward, if that was changed to dishonesty, because of course there's a definition for that. But it isn't, and it's without an honest belief in its truth, and it remains that now. Your Honour, at paragraph 28 of that judgment of Berry Piling, which can be found on page 246, Mr Justice Ackenhead says, on balance I conclude that it can be a contempt of a court for a witness to make a statement supported by a statement of truth recklessly. That is, saying something which it can be proved beyond reasonable doubt that he or she consciously had no idea whether it was right or wrong. This is supported by the wording of CPR Part 32.14. I pause there to ask the rhetorical question, well, is it? Is there anything contained within CPR 32.14 which does suggest that reckless falsity is included within that definition? And by the Vice-Chancellor in Malgar, when he said that CPR Part 32.14 did not introduce a new category of contempt. It is not undermined by the Edward Neal case, which was not concerned with whether reckless statements could amount to contempt. Recklessness, and we've read this before, recklessness is a concept that judges can address as they do in criminal context. Logic also suggests that a person who represents as true something which he or she consciously does not know whether it is true or not is consciously misleading the court and that should be considered as contemptuous. My lady asked the question earlier about the conscious recklessness, and I'll come to it in due course. There is some case law, and there is reference in my skeleton argument. The analogy or the example of the Admiral Nelson at the Battle of Copenhagen, putting the telescope to his wrong eye, his false eye, so as not to see the signal to say that he should not attack, would be conscious recklessness. He's consciously not asking the question. But I'll come to that in due course. Is that conscious recklessness, or is that just evidence of a lack of honesty? There is reference here to a number of cases, but in all of the previous cases, which are contained within your authorities bundle, there is reference to knowing without a reference to this reckless falsity. If I could take you please to the earliest of these, which would be Kirk and Walton, which is a 2008 case, please. And that is the permission hearing in which Mrs Justice Cox provided permission for an application for contempt. We found at page 97, please. The relevant passage is at page 97 of the bundle. Paragraph 97, the section is titled The Law, and it begins with reference to the same civil procedural, 32.14. At paragraph 25, it then continues to say, in Malgar and Leach, a decision of the Vice-Chancellor in the Chancery Division, dated the 1st of November 1999, the Vice-Chancellor, faced with a similar application, the first of its kind to be made since the civil procedure rules came into force, made some general observations about the effect of CPR 32.14. In general, the rule does not introduce a new category of contempt, but provides rather for the possibility of a person being prosecuted for contempt if he or she makes or causes to be made a false statement without an honest belief in its truth, in a document which is verified by a statement of truth. And this is the important part, on page 98. In order to succeed in such an application, an applicant who prosecutes and who has the burden of proving contempt to the criminal standard must show at the substantive hearing that the individual knew that what she was saying was false, and that her false statement was likely to interfere with the course of justice. No reference at all in relation to reckless falsity. Permission was granted in that case, and at the permissions hearing, Mr Justice Coulson also had to address the law to be applied. And this can be found at paragraph 8 of the judgment of Walton and Kirk on page 104, please. It might actually be paragraph 9, or there might be a typographical error in the print.
So sorry, which page?
Page 104, please.
It's the second paragraph 8.
It's the second paragraph 8, absolutely. Under the relevant test, it says CPR 32.14 allows for the possibility of a person being prosecuted for contempt if he or she makes or causes to be made a false statement in a document which is verified by a statement of truth, in circumstances when the maker does not have an honest belief in its truth. In order to succeed in such an application, an applicant who prosecutes has the burden of proving contempt to the criminal standard. And then there's reference to a case. In Caerphilly County Borough Council, Mr Justice Silbeck accepted at paragraph 14 of his judgment that in order to establish each attempt alleged, the applicant must prove beyond reasonable doubt in respect of each statement the falsity of the statement in question, that the statement has, or if persisted in, would likely have interfered with the course of justice in some material respect, and that at the time it was made, the maker of the statement had no honest belief in the truth of its statement and knew of its likelihood to interfere with the course of justice. Again, no reference to reckless falsity. Mr Justice Actonhead in the Berry Piling case specifically referred to the case of Neal, a 2011 case, which, and the relevant section in relation to that can be found at page 135, please. This is Neal and Loveday.
Sorry,
In the case,
would you give us the page number again?
of course, it's page 135.
Thank you.
The relevant section begins at paragraph 9 at the bottom of page 135, and it is referenced and quoted within Berry Piling. Paragraph 9 says, as Sir Richard Scott VC, as he then was, noted in Malgar, this did not make any change to the law of contempt, and it was still necessary for it to be shown that in addition to knowing that what you were saying was false, you had to have known that what you were saying was likely to interfere with the course of justice. The standard of proof, of course, in respect of each of the elements of contempt, is proof beyond reasonable doubt, the burden of proof that being on the party who is bringing proceedings for contempt. It's worth noting that there is a repetition of knowing. It's knowing that the statement was false and knowing that there would be an interference with the administration of justice. There is no reference to recklessness in relation to either of those elements of the offence or the elements that need to be proved. And finally, and this is the case that is referenced by all of the subsequent cases, is the case of Malgar. Now, Malgar begins, or the reference that you've heard repeatedly so far is that the introduction of the civil procedure rules has not changed the law in relation to contempt. And if I could take, my lord and my ladies, to page 54, please. The reference in Berry Piling is that it is, I think, necessary to make clear, and this is the quote that's been contained, or the reference contained in Berry Piling, it is, I think, necessary to make clear that rules of court cannot make substantive changes in the law of contempt. And that's the beginning of the last paragraph on page 54. But what's interesting in relation to that paragraph is that if you read the context of the paragraph on either side, starting halfway down the page on page 54, it addresses what the law was prior to the introduction of the civil procedure rules, the CPR. It talks about the use of affidavits, and the fact that if a falsity was contained within an affidavit, then you could be pursued in perjury. But in those circumstances, again, it was required that you knew that the statement was false. That appears to be the common law position before the introduction of the CPR. Just halfway down page 54, the introduction of statements of truth raises the question how the use of the statement of truth can be policed. Affidavits were of course sworn. To knowingly swear a false affidavit was always has rendered the maker liable to be prosecuted for perjury, a criminal offence. It has often been observed that the maker of affidavits whose content were held in judicial proceedings to be untrue were very rarely prosecuted. The sanction of prosecution for perjury as a means of trying to ensure that false statements were not made in affidavits was not a very real one. A much more real sanction was that an individual who had sworn to facts which appeared to be to the judge considered to be false would inevitably have his credibility so impugned as to make it quite unlikely that it would persuade the judge of the veracity of other critical parts of his or her evidence. Be that as it may, some means of policing the statements of truth is necessary. The solution was CPR Rule 32.14. CPR Rule 32.14 provides as follows, and then it's quoted, hence the application to me this morning for permission. It is, I think, necessary to make clear the rules of court cannot make substantive changes in the law of contempt. There is much case law describing in what circumstances a contempt of court is committed. There are civil contempts and there are criminal contempts, and the line between the two is not always easy to draw. But the circumstances which must justify the finding of contempt are established by case law and set out in the textbooks on the subject. The importance of that passage, my lord, my ladies, is that very piling doesn't refer to any previous common law authority either in relation to the creation of reckless falsity. And it's clear from the case of Malgar that that authority, those previous common law authorities, would have potentially been relevant or applicable. The other interesting point in my submission in relation to that passage is to understand what is the purpose of the statement of truth and what is the purpose of contempt of court. Is it to try and make witness statements reliable, or is it to punish or prevent people from lying in witness statements? Because if it's a suggestion, if going back to before the CPR, the idea would be, well, if you lie, if you perjure yourself in a witness statement, you will be prosecuted for a criminal offence of perjury. But if you are unreliable, reckless, do not check your information, and it undermines your credibility, that would not be a criminal pursuit of perjury. That would be a failing, in all intents and purposes, in whatever action you were pursuing. Because ultimately the question for this court is going to be, well, what's the purpose of the contempt of court proceedings? Is it to capture the consciously reckless, or is it to capture the person who acts without honesty? For completeness, the Sony cases, and I refer to them as the Sony cases, it's the Kabakushi Kaisha Sony computer cases that can be found beginning on page 68. The first page on page 68, but the relevant section is page 77, please. And these cases were not, strictly speaking, in relation to the test to be applied, rather in relation to the evidence, or the threshold of evidence that needs to be applied. I will come to that in due course. But there was reference at page 77 to the requirement that a person know rather than is reckless to, or that in fact there's no reference to reckless. The middle of the page, paragraph 24, on page 77. The need for permission, whereas here the proceedings are brought otherwise than by the Attorney General, enables the court to confine the proceedings to cases where there is a real prospect. I do not think there needs to be a certainty that the applicant can establish A, the falsity of the statement in question, B, that the statement has, or if persisted in, it would be likely to have interfered with the course of justice in some material respect, and C, that at the time that the maker of the statement had no honest belief in the truth of that statement and knew of its likelihood to interfere with the course of justice. Again, it's reference to knowing and in relation to interfering with the course of justice and no honest belief in the truth of the statement. And my lord, my ladies, in our submission, very pilings is not soundly reasoned, and it is not the correct test to be applied. The correct test to be applied is that contained within KJM Superbikes. KJM Superbikes, just for completeness, was about the import of Honda motorbikes from Australia into the United Kingdom. Each of the Honda areas were permitted to sell. So Honda UK was permitted to sell in the UK. Honda Australia was allowed to sell in Australia. But Honda Australia gave some motorbikes to a company called Lime Exporting, who were permitted to export to the Pacific Islands, Fiji, etc., who didn't have sufficient market to have their home Honda store. Actually, what happened was that Lime Exports were exporting to the UK as well. A chap called Hinton, who worked for Honda Australia, wrote a witness statement saying, we didn't know anything about that. It then turned out to be demonstrably false. And he subsequently wrote a witness statement saying, no, that was false. And we always knew that they were being exported to the UK. Contempt of court proceedings were against him, were taken out against him. The permission was initially refused, and the matter went to the Court of Appeal, and permission was then considered again. The relevant page in relation to the test to be applied is on page 83, please. Page 83. Paragraph 7, it says the judge recognises that KJM being the UK-based company that was importing the Hondas, the judge recognised that KJM's desire to take proceedings against Mr Hilton was motivated largely by anger. He did not find that surprising, since it had been successful at the trial, after having only narrowly avoided summary judgment being entered against it at a time when it did not have much, if any, material with which to challenge Mr Hinton's lies. However, he rightly identified the question he had to decide as being whether it was in the public interest for proceedings to be pursued against him for contempt. And that is ultimately the test. Is it in the public interest for proceedings to be brought against a person who is alleged to have committed a contempt? Moving on to the next page, on page 84, the Court of Appeal in that case, again referencing the case of Malgar at paragraph 9, highlights that contempt of court, bringing actions for contempt of court, is a public law proceeding. And proceedings for contempt of court are public law proceedings, and therefore, when considering whether to give permission for proceedings to be taken in any particular case, the court must have regard to the public interest alone. So again, the test, the correct test to be applied is it in the public interest? Interestingly, in the next sentence, there is reference again to knowingly to give a false evidence. I'll come to that in a few moments, but again, reference to knowingly. And at the bottom of page 84, in paragraph 11, a witness who knowingly makes a false statement in the course of giving evidence, orally or in an affidavit, does not expose himself to an action for damages at the suit of anyone injured as a result, but he does expose himself to the risk of prosecution for perjury, and as such is publicly accountable for his attempt to interfere with the course of justice. Since the introduction of the civil procedure rules, witness statements made for us in procedural applications, as well as documents of many other kinds, must be supported by statements of truth. Statements of truth are not made on oath, but the principle that a person who knowingly makes a false statement intended for use in proceedings should be held accountable is equally applicable. Whilst the test, in my submission, or the correct test to be applied, is whether bringing permission is in the public interest, there is, of course, a number of factors to be considered when considering the public interest. And these are identified at paragraph 16 of the Court of Appeal. On page 86, please, paragraph 16. Whenever the court is asked by a private litigant for permission to bring proceedings for contempt of court based on a false statement allegedly made in a witness statement, it should remind itself that the proceedings are public in nature, and that ultimately the only question is whether it is of the public interest for such proceedings to be brought. However, when answering that question, there are many factors that the court will need to consider. Among the foremost are the strength of the evidence tending to show not only that the statement in question was false, but that it was known at the time to be false, the circumstances in which it was made, its significance having regard to the nature of proceedings in which it was made, such evidence as there may be of the maker's state of mind, including his understanding of the likely effect of the statement and the use to which it was actually put in proceedings. Factors such as these are likely to indicate whether the alleged contempt, if proved, is of sufficient gravity for there to be a public interest in taking proceedings in relation to it. In addition, the court will also wish to have regard to whether proceedings would be likely to justify the resources that would have to be devoted to them. I don't want to skip ahead too much in my structure, but one of the questions that was asked by Lord Justice Stuart Smith was on whether there are particular features to be borne in mind in a case alleging contempt of court by a police officer in seeking to obtain and obtaining a warrant. In my submission, there should be no separate law in the consideration of a police officer who may be in contempt of court and any other witness who is in contempt of court, or potentially in contempt of court. And the circumstances or differences between those two individuals, the police officer and the lay person, can be properly addressed within the boundaries or within the precedent set out by the Court of Appeal and KJ and Superbikes. Because, as is set out in paragraph 16, the court's discretion is influenced by a number of considerations. The primary one being a strong prima facie case, or the strength of the evidence. But of course there are other factors which the court can take into account. And those other factors being, for example, the nature of the application, or whether a person was a police officer in comparison to another professional or a lay person, is something that can be taken into account. So in my submission, when you look at the factors identified by my learned friends, by the appellants, whilst those factors are clearly potentially relevant to a court, they are just relevant within the context of the precedent case of the authority of KJM Superbikes. It's noteworthy, and continuing on paragraph, on page 86, that the Court of Appeal, paragraph 17, said, in my view, the wider public interest would not be served if courts were to exercise the discretion too freely in allowing proceedings of this kind to be pursued by private persons. And that may be relevant to the consideration of what level of prima facie case, strong prima facie case, the type of evidence that is necessary in order to overcome the threshold to bring a contempt of court, to allow permission for contempt of court. The reference to strong prima facie case, because my lady asked earlier, I believe my lady asked earlier about, well, is there any authority for any definition of what is a strong prima facie case? Well, my learned friends are correct in that there is no single definition. There is no one case that says, well, this is what strong prima facie case means. In my submission, and I'll take you to it in a moment, the Sony case provides the basis for a strong prima facie case. And what I'd like to do, and will do in a few moments, at paragraph 4 of my skeleton argument, section C, is highlighted the factual matrix in relation to a number of cases and the level of evidence that is required to overcome that threshold. So whilst it might be correct that there is no one definition, in my submission, the Sony case, which, if I could ask you please to turn to page 64, does provide some guidance.
Before we leave page 86, which is obviously at the heart of your submissions, Lord Justice Moore-Bick, in the penultimate sentence of paragraph 17, which is perhaps the ratio of KJM, uses the phrase a strong case. I wonder whether there's any difference between a strong case and a strong prima facie case at the permission stage.
My Lord, I think that the important word there is strong, and that word is used in the Sony case, which I'll take you to in a few moments, and is used subsequently in authorities which then attach that word strong to prima facie. So it's clearly a caveat that means it needs to be certainly more than a prima facie case. And what I would hope to do when I go to my skeleton argument is highlight what constitutes strong. Because in my submission, strong is akin to admitted falsity. Perhaps not quite that level, but certainly very high.
Yes, sorry, you were going to take us, what, next to your skeleton argument?
My Lord, just
4. Oh, the Sony case, I'm sorry.
If I may, just before I take you to...
This is page 64, is it?
It is.
Yeah.
Thank you, lady. It's page 64,
Yes.
paragraph 17. It's judgment of Mr Justice Kerr. Paragraph 17, it says, it seems to me also that before this discretion is exercised, having referred to above the case of Malgar and Lynch and the discretion to permit applications for contempt, paragraph 17 says, it seems to me also that before this discretion is exercised, the claimant must satisfy the court that there is a strong case, and preferably an admitted case, that a particular misrepresentation is untrue. Here there is in relation to the following alleged non-disclosure, 2 admitted non-disclosures. That is to say, and it goes on to say, the Guernsey bank account and the extent of purchases from a man who is referred to as Boris and is the third defendant. So it's referenced there to what is considered to be strong. And this was followed by Mr Justice Cox, I believe, in Kirk and Walton. If I could take you, please, to page 99. Beginning on page 98, paragraph 28, you'll see that there is reference to the Sony case, the Sony Computers case, which I've just taken you to, and the 2 paragraphs, paragraphs 16 and 17. There's then reference to, in paragraph 18, he used the word strong prima facie case, and at 22 said the court must be astute not to allow tenuous or argumentative applications to commit to go forward. And then it said at paragraph 29, I approach the present case, therefore, on the basis that the discretion to grant permission should be exercised with great caution, that there must be a strong prima facie case shown against the claimant, that I should be careful not to stray into the stage of the merits of the case, that I should consider whether the public interest required committal proceedings to be brought, and that such proceedings must be proportionate and in accordance with the overriding objective. In my submission, the correct test is whether it is in the public interest. Whether it is in the public interest has a number of factors. The first of those factors is whether there is a strong prima facie case. Because, of course, in my submission, might be of course, but in my submission, if there is no strong prima facie case, it doesn't matter who the individual was or what the potential outcome of that falsity may have been. Because if you can't show that that person knowingly made a false statement, then it must fall there. My Lord, I then will move to my skeleton argument, which is on page 42, 4 bundle. I move to my skeleton argument because I tried to, as best I can, highlight the relevant facts in relation to each of the cases that I'm going to refer to, and to distill them into my skeleton argument.
Yes.
Rather than taking you to the passages or try to read out the facts of each of the case. The first paragraph I'd like to take you to, I've made points in relation to paragraph 4.1. It must be a strong prima facie case. Paragraph 4.2, I highlight that in Malgar, held that permission should be granted for flagrant and obvious breaches. Again, perhaps language that may be useful in deciding on what constitutes a strong prima facie case, something which is flagrant or obvious. Again, a point raised by my learned friend, it must be astute not to allow, paragraph 4.3 must be astute not to allow tenuous or argumentative applications to commit to go forward. My learned friend suggested, well, a strong prima facie case is just one step above tenuous or argumentative. In my submission, that's not correct. The strong prima facie case is significantly higher than that, but of course, tenuous and tenuous or argumentative applications should not be allowed to proceed, because if it's tenuous, it's certainly not a strong prima facie case. Turning first of all then to KJM Superbikes Limited, which is, in my submission, the precedent case. I've already highlighted the facts in relation to that. Mr Hinton, who was subsequently, contempt proceedings were not brought against Mr Hinton, but then it went to the Court of Appeal and permission was granted for an application of contempt. He wrote a witness statement in which contained the full statement, and then wrote a second witness statement in which he admitted the falsity in the first. That, in my submission, is a strong prima facie case. It's an admitted breach, an admitted falsity. And in Kirk and Walton, paragraph 4.6, there were repeated signed statements from a defendant professing various levels of severe disability. And my lord has already picked up that this was a disability case, an insurance case, or a disability allowance case, disability case. Repeated signed statements from a defendant professing various levels of severe disability, and then multiple instances of covert surveillance footage appearing to show that these assertions were demonstrably false. The strong prima facie case of Mrs Kerr deliberately stating a falsehood included direct video evidence and expert witness statements following medical examination. At the permission stage, the allegations of falsehood appeared flagrant and obvious. However, it's worth noting that in the full hearing, in spite of apparently incontrovertible evidence, only 2 of the 14 alleged contempts were made out. And I've quoted there for you. It's a paragraph 130 of Walton for Mr Justice Coulson. In light of the high standard of proof in a case such as this, I have on a number of occasions felt it appropriate to give Mrs Kirk the benefit of the doubt in considering the allegations of contempt through gross exaggeration. Again, just trying to provide some sort of idea of what the threshold is. In Berry Piling itself, permission wasn't granted in Berry Piling. And that's why I say that the comments in relation to reckless falsity or reckless falsehood was overturned. Because despite the fact that this lower standard, this lower threshold was put in place by Mr Justice Kerr, it still wasn't met. It still wasn't met, despite the fact that there was 3 lever arch files of evidence and an expert report. Just to provide a very brief summary, this was in relation to a case in which directors said that there was money in the management accounts, that there was sufficient funds to proceed to a court hearing, and then there was an expert report saying, in fact, when that statement was made, the directors had failed to take into account debts that were clearly obvious and that had been defaulted upon, and that the financial position that they put forward was clearly false. In fact, the court found, the High Court found, that that wasn't the case. It wasn't clearly false. It didn't meet that strong prima facie case. In Stobbard Group and Elliott, Stobbard Group being another name for the Tinkler case, permission was granted to apply for an order of contempt of court in relation to 7 alleged false assertions, but was then overturned on the basis that the judge's view on whether there was a strong prima facie case was clearly wrong. And Lady Justice Gloucester referred to the judge disregarding an apparent lack of motivation towards telling a deliberate lie. Paragraph 53. Moreover, there was no reason whatsoever for Mr Tinkler to have lied about this matter. It would have served no useful purpose and could have easily been rebutted by an inquiry of the CAA. Again, that might be a relevant consideration when coming to the merits of this case. What motivation is there to lie? The level for a strong prima facie case, in my submission, is a very high one. It is akin to admission that you have said something false, or that it's demonstrably provable based upon medical evidence and video footage. It is not simply whether there is an inference, it's whether that inference can be demonstrated. And it's certainly, in my submission, higher than just above tenuous or just above argumentative. I'll deal with the merits in relation to the current case in due course, but that, in my submission, is the level. The second question of Lord Justice Stuart Smith was whether there are any particular features to be borne in mind in a case alleging contempt of court by a police officer in seeking and obtaining a warrant. In my submission, there shouldn't be a separate test, as I've said, in relation to any particular profession. But something that might need to be borne in mind when dealing with police officers is that contempt of court application is against an individual, a person. It is not against a police force. And what the court should be wise not to do, or aware of, is not to attribute to an individual what was known by a police force or what could have been known by a police force. And there's clear authority in relation to that.
I don't think Mr Metzel would suggest otherwise. It would plainly be wrong. If an application is made against individual A, individual B, in each case it must be shown that the individual had committed a contempt.
My Lord, thank you very much. I'm simply answering the question, but it's set out in my skeleton argument, paragraph 5, and I've highlighted the relevant authorities. And my Lord, then, is the final question is in relation to paragraphs 24 and 28 of Berry Piling Systems Limited. Our primary position is that this wasn't soundly reasoned. It was simply a conclusion that was made on a reading of the CPR. However, if we are wrong, there is further authority to the consideration of what constitutes reckless falsehood, because it can't simply be, in my submission, not checking. There needs to be some subjective element. There needs to be some sort of malice or some sort of individual malice, malfide, something that an individual has done which is wrong. It can't simply be the person who hasn't checked. Because if it was simply the person who didn't check, there could be, taking the most extreme example, contempt against the honest imbecile, the person who simply didn't know what they were doing was wrong, that simply they didn't know what to check or how to check it. That person could be exposed in proceedings here or in any court, and then be liable to contempt of court proceedings. the cross-examination of someone going, "Didn't you check this?" and me going, and that person, that witness going, "No, I didn't," could be liable to contempt proceedings because they put in a statement of truth something which they believed to be true, but was turned out was not appropriately checked, and that can't be what the contempt of court proceedings were aimed at. And there's authority to that point. First of all, before I move on to that authority, I just want to deal with the Stobart Group and Elliot, the Tinkler point. My lord, I believe, has already picked up on the point. I don't seek to repeat it. At paragraph 45 of the Tinkler Group, the Tinkler authority, paragraph 45, and I don't ask you to look it up here because my lord has already made the point. It is not ever necessary for the court to revisit these authorities, list of authorities that were referenced. The dispute on the appeal focused on whether the judge had correctly applied them. The Court of Appeal in that case was not turning its mind, did not hear argument in relation to whether Berry piling was correct. And it simply took as agreed between counsel that it was correct. And in my submission, perhaps, we will never know whether the Court of Appeal would have agreed or disagreed had that been argued in front of it. But in my submission, that is not authority that overrules or contradicts, is sufficiently authoritative to contradict what is in KJM supervised. Turning then, please, to my skeleton argument on page 48, paragraph 6.9, and the case of Newsom Smith and Al-Zawani. Now, Newsom Smith and Al-Zawani was a case in which the court, albeit the High Court, the court did consider this concept of reckless falsity and whether it was merely not checking or whether there needed to be some element of conscious not checking. At paragraph 8, there was specific, and this I do apologise, this is page 454, please, of the authorities bundle. 454 of the authorities bundle, and page 48 of my skeleton argument, the core bundle, please. The High Court here were considering the obiter comments of Berry piling systems and whether and to what extent you were required to consciously engage with the reckless falsity. Was it enough not to have checked, or was it more to have consciously not checked? The decision was, or the judgment was, that there was a burden to prove that the maker of the false statement had consciously engaged with the issue, which was an additional element to recklessness. This again is secondary to our primary submission. This is not what we suggest is correct, but this was what was considered. Beginning at paragraph 8, and I've set it out in my skeleton argument, and also beginning in the authorities bundle, paragraphs 8 to 12. So a false statement is one which was not true, and which, when made, the maker knew was not true, or did not honestly believe to be true. There is a fine dividing line between mere carelessness or negligence on one hand, and recklessness in making the statement on the other. Recklessness is a sufficient mens rea for contempt, and then Berry piling systems is referenced. However, the statement is made recklessly only if the maker consciously had no idea whether it was right or wrong. And paragraph 28 of Berry Piling is set out there. Carries on in relation to quote paragraph 30C of Berry Piling. Optimism or even carelessness in making of the statements will not be sufficient to establish that a party is in contempt. Paragraph 9 of Newsom, Smith and Al-Zawani. At this point, and only in relation to this point, the parties' submissions diverge. They take different views on what recklessness means in the context of false statements. The applicant argues that if the maker of the statement does not take sufficient steps to check whether the statement is true or not, then he makes a reckless false statement because he can have no honest belief in the truth of it. The respondent argues that a failure to conduct sufficient checks is insufficient in and of itself to render a statement false by recklessness, because the makers may still believe the statement to be true, even if he has not conducted those checks. It is only if he does not care whether it is true or not, a different and higher hurdle to surmount, that it can be said that he lacks an honest belief in the truth of the statement. It then goes on to reference another case, which I will go to in a few moments, but just carrying on. In resolving this divergence of views, I'm assisted by the Court of Appeal judgment in JSC, BTA Bank and Eroshenko. In that case, the applicant argued that the respondent, Mr Eroshenko, was in contempt because he lacked an honest belief in his statements to the court, based on his failure to engage with terms of a Norwich pharmaceutical order, and his failure to make reasonable lines of inquiry into the truth of the position. Lord Justice Lloyd reflected that argument, saying this: what the bank has to persuade the court of to make out its case of contempt as regards any of the statements in question is that Mr Eroshenko's statement was not true, and then when he made it, he knew it was not true or did not honestly believe it to be true. That applies to every aspect of Mr Eroshenko's relevant statement. If Mr Eroshenko had not in fact made all reasonable inquiries before making his statement in answer to the disclosure order, then in that respect the answer may be untrue. If the answer includes a statement, express or implicit, that he has made all reasonable lines of inquiry, the bank may be able to show that this is the case and Mr Eroshenko has not applied his mind properly to the obligation. That is an objective question. But to prove this does not show that Mr Eroshenko knew that his inquiries, whatever they may have been, were not all that he could and should reasonably have made. The question is subjective and depends on Mr Eroshenko's state of mind when he made the statement. It is not to be overridden by policy positions that a respondent must not be allowed to get away with making objectively inadequate compliance with the order. To show that not all reasonable lines of inquiries have been made may be enough to justify a supplementary order designed to reinforce the original obligations. It does not by itself justify a finding of criminal contempt based on dishonesty. The Court of Appeal dismissed the appeal, upholding the judge's refusal of permission to bring proceedings to commit Mr Eroshenko for contempt. Paragraph 12, the passage cited refers to Mr Eroshenko applying to his mind to the truth or otherwise of the relevant statements. That reflects what Ackenhead J said, Mr Justice Ackenhead said in Berry Pilings, namely that a false statement is made when the maker consciously has no idea whether it is right or wrong. There must be a subjective element, that is a conscious engagement with the issue which is a subject of the statement before it can be said that the statement, if it turns out to be untrue, was made recklessly, and thus without an honest belief in its truth. Anything less than conscious engagement is likely to amount to mere carelessness. I agree with the respondent and reject the loser's approach to recklessness. I'm grateful for these earlier submissions that came from there. I want to just turn to the Eroshenko case and the authority there, and then make my general submissions. But I'll just highlight them now, or flag them now. The primary submission is, as I've stated, that Berry Piling was badly or not soundly reasoned. Whilst these cases, I come to Eroshenko in a moment, highlight a gloss in relation to reckless falsity, to what extent does that gloss not just highlight, as an evidential position, that a person who consciously engages in recklessness or reckless falsity, who consciously engages in reckless falsity, is in fact being or lacking in honesty. A person who consciously does not check, or a person who recklessly misstates something, is that not merely indicative of them acting without honesty? Going back to Mr. Metzer's example earlier, if he stands up and forcefully says to you, I know what happened on the last occasion, and honestly believes what he says to be true, is he in contempt of court? Whereas if he knows what he says is untrue, of course he is in contempt. If he does so recklessly, is that not just indicative of a lack of honesty, depending on how reckless he is? At what stage is the barrister who states something forcefully reckless?
Well, probably bringing advocates into it is unhelpful, because you have all sorts of complications about duty to the client and what you knew personally and all that. But you say really that the phrase in the rules, without an honest belief in truth, the important word is honest. And somebody can be honest or dishonest. And you say the test is only made out if there's a strong case, strong prima facie case, that the maker of the statement was dishonest or not honest.
Acting without honesty, yes. Just dealing with the sort of the Abner Nelson example. If he holds the telescope to his wrong eye, do you want to pursue him for contempt of court because he's been reckless, or because he's not been honest? I come then to the Eroshenko case. And I come to it last, and I come to it because I wish I'd been the person who come up with the Adler Nelson, but it's contained within this case.
I'm not sure it's terribly helpful anyway, but let's have a look at the Eroshenko case.
It begins, please, on page. It begins, please, on page 253. But the first reference that may be of use is on page 261. In this case, this was a Court of Appeal case in which the application was for, like here, for application for permission for contempt of court. The appeal was dismissed, and that the previous decision not to grant permission was upheld. At first instance, this can be seen on page 144, the judge concluded that the respondent, the person whom permission was sought, Mr Eroshenko, behaved like an ostrich. We can see that at page 1, paragraph 144, in that he had sought not to engage in a process of disclosure. The judge at first instance had concluded that Mr Eroshenko was a careful man, but was overwhelmed by the stress of the situation and consciously had decided not to engage with the process. as a result, they said that he'd acted like an ostrich. He'd submitted a witness statement in relation to the disclosure order, and this was the December statement, in which he said that he could not recall certain points. It was subsequently shown that he could recall those points because in subsequent statements he provided recollections and provided answers. The conclusion of determination in relation to the first instance, or the lower court, is at page 262, and the determination is set out. The paragraph 148 there is the determination from the lower court. An appeal was brought forward, an appeal was lodged, and it was suggested that Mr. Eroshenko had deliberately lied. If I could take the court, please, to page 267. Effectively, the appeal was brought on in two ways. First, there was an appeal on the basis that the judge had erred in law by concluding that Mr. Eroshenko had acted like an ostrich, but not found that there was permission for contempt of court. In the same respect as this, that the judge had failed to engage with the concept of reckless falsity. He had consciously avoided or consciously engaged with the process. The second area of appeal was that the judge in the lower court had just not got the facts right.
You said permission. I don't know this case very well, but I thought Mr. Justice Voss was doing a full application to commit, and it was in mega litigation and probably didn't need permission. I don't know. Anyway.
No, you are right, and I do apologise. Yeah. I know. Please don't hold me in contempt. I do apologise. I did get that wrong.
Well, you had an honest belief. Yeah. Okay. Anyway, this is the appeal from Mr. Justice Voss's dismissal of the substantive contempt application.
That's absolutely right. Thank you, my lord. And absolutely. And there were two areas. One in which there was a misunderstanding of this ostrich point, and then a second appeal on the basis that they just got the facts wrong. Mr. Justice Voss got the facts wrong. I take them, please, to paragraph, page 269, please. Paragraph, beginning on paragraph 41, and I just summarise it. Mr. Smith, who was counsel for the appellant, challenged the judge's conclusion, which sought to characterise as a point of law, was based on the judge liking Mr. Eroshenko to an ostrich, the comparison which we were told was the judge's own idea, mentioning the first time the closing submissions. It then goes to the point about analogies. Mr. Eroshenko was telling the truth in what he said in respect of the charges as contempt, and B, if not, whether he had or did not have an honest belief at the time the relevant statement was true. Mr. Smith argued that it could not and should not be a defence for a respondent to a committal application to reply from a position in which he has hidden his head in the sand, or in which he has, as the judge said at paragraph 149, in a state of denial. Mr. Smith argued that such state of mind amounts to a deliberate refusal to engage with the obligations under the order, such that Mr. Eroshenko must have known that he was not responding to the order to the best of his ability. In particular, he submitted that Mr. Eroshenko had deliberately refused to engage with the obligations under the disclosure order by refusing to apply his mind properly to the question posed and to his obligations to make reasonable inquiries. The Court of Appeal responded, I do not accept that, this is paragraph 42, I do not accept that position. What the bank has to persuade the court of to make out its case of contempt as regards each or any of the statements in question is that Mr. Eroshenko's statement was not true, and that when he made it, he knew it was not true, or did not honestly believe it to be true. That applies to every aspect of Mr. Eroshenko's relevant statements. If Mr. Eroshenko had not, in fact, made all reasonable inquiries before making his statement in answer to the disclosure order, then in that respect the answer may be untrue if the answer includes statement express or implicit, and that he may made all reasonable line inquiries. And this is the point that's been quoted in the previous case, the High Court case that I mentioned. The bank may be able to show that this is the case that Mr. Eroshenko had not applied his mind properly. The obligation, that is an objective question, carries on. Then at paragraph 43, there is comparison to the ostrich and Admiral Nelson analogy. I won't go through it again, but it is there. My lord, my ladies, in my submission, it's the idea of reckless falsity. It was developed in a case very piling without any previous authority, and in every instance where it has been considered subsequently, it's never been challenged, simply accepted in the Tinker case, and in which the one case that did engage with it, which was the Newsom Smith and Al Zawani case, came to the conclusion that it's not simply enough not to check, which appears to be what my learned friends seem to be saying. It needs to be much more. And I don't suggest, in fact, when you consider what that much more is, that consciously being reckless in what you are saying, consciously being reckless in what you're saying is so close in my submission to not acting with honesty, subjectively, that there is no, or there shouldn't be, a distinction. And that this court should conclude that there shouldn't be a distinction. And that this court should conclude, in fact, that the proper test to be applied is one of subjective honesty. If a person is acting with subjective honesty, then they are not in contempt. Dealing then with the merits of the appeal, and I can do this quite quickly because I hope I can do this quite quickly, because in my submission, Mr. Justice Kerr did not fail to engage in any of the arguments that were put before you today, those arguments having been put before Mr. Justice Kerr in the High Court. The correct test to be applied was the test in KJ and Superbites. Mr. Justice Kerr considered the arguments that were put forward by the applicant. He considered the point of reckless disregard. He considered whether berry piling was appropriate to be applied. And ultimately, he applied the one true test. That one true test being whether it is in the public interest to grant permission. And his conclusion was it was not in the public interest. It cannot be suggested that he failed to engage with the concepts contained within berry piling, those concepts being brought to his attention on repeated occasions by learned counsel. Therefore, in my submission, that ground of appeal must fail. Similarly, with regard to the specific words within the declaration, I don't seek to go through or give you too many references because the references are contained within my skeleton argument at paragraph 8, page 50, in relation to the correct test to be applied. Paragraph 9, page 51, suggestion that Mr. Justice Kerr failed to engage with the specific words within the direct declaration. Again, that's just not correct. The specific words of the declaration were brought to his attention on a number of occasions. And he considered those words and came to the conclusion that it was not in the public interest to grant permission. with regard to the third ground, I haven't gone into my points with regards to attributing information or attributing knowledge in relation to one individual or in relation to an organisation to each individual. In my submission, what the appellants are trying to do is bring proceedings against the police force, which they have already succeeded in to some extent in the warrant application, the judicial review with regards to the warrant. What my learned friend has not done, despite taking you to numerous documents, for example, the SEC applications and filings, or even the transcripts, is demonstrated that this was information that was necessarily available to both respondents, in particular the first respondent. My learned friend took you to his statement. If I could take the court, please, to page 210 of the permissions bundle. My learned friend took you to paragraph 8 of the witness statement provided by the first respondent, and particularly to paragraph 8.3 on page 210, that company inquiries indicated that Blue Tractor Europe showed adornment. It was suggested that that was evidence that this respondent had considered points relating to, for example, Company's House. And my lord highlighted that it was somebody had checked Company's House records. In fact, if you look at the first line of paragraph 8, it states, financial intelligence officers conducted checks on Mr. Norton Sr. There is, in my submission, no evidence that the first respondent himself carried out checks in relation to Company's House. The first respondent was perfectly entitled to rely upon information provided to him by financial intelligence officers without checking it. Whether it was wise or not, he was entitled to do so. And then with regard to the SEC applications, in my submission, that is dense material. It is dense material that is not easily understood by highly trained and highly intelligent lawyers and judges, let alone someone who is picking this up without any form of context. And whilst it was, and the judicial review found that it was inappropriate for that not to be raised with the Crown Court judge, is that strong prima facie evidence, strong prima facie case, that that first respondent was dishonest or acting without honesty? My submission is that that is not.
Were the other things in paragraph 8 correct?
Yes.
No income tax since 2008, etc.
And without giving evidence, and I'm not going to, there was the parts of the warrant application were clearly correct.
Well, we've got the judgment of the divisional court, which sets out a number of the facts.
Cash being found on the premises, for example.
Yes.
With regard to the first respondent and the second respondent, the first respondent had some overarching responsibility. The first respondent was not the most senior person within the team, and that's identified by Mr Justice Kerr. Whether the first respondent provided all necessary information to the second respondent, there's no evidence of what information was provided. And again, it's not on the respondents to for an allegation or an assertion to be made, and that allegation or assertion to be answered. That's simply not what the case law says, and not what the case law should say. A criminal allegation, effectively, I'm not saying it is quasi-criminal, but a criminal allegation is being made by the appellants, the applicants, and they need to prove their case to that strong prima facie level before any response is required. And you can't attribute to the second respondent what the first respondent knew or what the first respondent may not have known, but the police as an entity may have. Mr Justice Kerr engaged with that concept, and he was not wrong in law by rejecting the applicant's submissions that these individuals knew things when there was no evidence that they did. In fact, Mr Justice Kerr properly applied the law as set out in Connolly Bailey, as set out in the O'Hara Principle. With regard to speculation, with regard to honesty, I'm slightly confused by that as a ground of appeal. Because in my submission, speculating on the honesty of the individual, not speculating, but judging the honesty of the individual, is exactly what a permission application is about. There must be, at the permission stage, a judgment as to how honest a person was, whether they were acting with honesty or without it. And what Mr Justice Kerr did was come to a conclusion that there was a range of possibilities, a range between honest mistake to nefarious intent. And when he was considering that range, thought about, as in the previous case that I've highlighted, thought about, well, what would be the motivation of lying? In comparison to the fact that we know there were 5 applications in relation to this warrant. And we know that the application in relation to the one that was ultimately successful, the 5th, the 4th application, we know the judge sent that officer away because there had been an error, because there was a mistake. In my submission, Mr Justice Kerr was perfectly entitled to come to a conclusion that the second respondent was in over her head. Because that's what could be inferred from the evidence that was put before him. And it certainly wasn't, there wasn't sufficient strong evidence to suggest that there was a nefarious intent. And finally, the impact on the appellants. Of course, Mr Justice Kerr engaged with that. The learned judge held that the warrant should not have been applied for or granted. Consequently, must have considered the impact on the applicants, on the appellants. That's page 109, paragraph 35. The impact of the appellants is only one of many factors when considering the public interest test, the ultimate test, and Mr Justice Kerr did not overlook this factor. My Lord, I've highlighted on page 53 of my skeleton argument, paragraph 13, a point that I've just made really in relation to requiring the respondents to set out their stall, as it were, requiring the respondents to say whether it was a negligent mistake, whether it was misinformation provided to them, whether it was, I'm trying to find the exact point, I do apologise. My learned friend sets out in his speaking notes it is noteworthy that R's acknowledgement of service does not set out any claim that either respondent was misled by any third party, was negligent, not that such an assertion would itself be sufficient to absolve the respondents, or otherwise fell into honest error. There is no requirement, as I have already said, there is no requirement for the respondents to have provided any explanation at this stage. However, there is a requirement upon the appellants, the applicants, to prove to you, using a strong prima facie case, that those things are not relevant for your consideration. The appellants need to show you that these respondents were not misled by a third party, were not merely negligent, and did not otherwise fall into honest error. Because that's the very nature of the application, to provide a strong prima facie case to show those things were not the case and that in fact it was acting without honesty. And in my submission they have not done that. My Lord, my conclusion is set out in paragraph 14. The correct test is one of public interest. Very highly, it was not soundly reasoned, and there is no merit in this appeal.
Thank you very much, Mr. Thomas. Mr. Metz.
Thank you, my Lord. The most important submission that we make in reply, and our respectful submission, is that the defendant is simply wrong when he says that the very piling decision is obiter. Taking and, of course, acknowledging my Lord's observation in relation to the KJM case, of course, not only does it mention both Mulder and Neild, we respectfully submit it's conspicuously well-reasoned and, importantly, applied in 3 Court of Appeal cases. You've seen Tinkler, I don't need to take you back to that, that's at pages 365 to 366. But importantly, 2 other cases, sorry, first one was the second case, the Newson case, is in the High Court. Tinkler, as I've said, is the Court of Appeal. Newson-Smith is significant in our respectful submission. First of all, because you'll have seen from my learned friend's submissions contained within his skeleton at paragraphs 6.9 and 6.13 that he argues that Newson-Smith is good law and indeed relies upon an alternative case in relation to recklessness at 6.13. If we could just briefly go to that case in the High Court.
Can you just mention what the third, you said very piling has been approved in 3 subsequent cases.
Yes.
We know about this court. Newsom, Smith, Mrs. Justice Whipple.
Yes.
And what's the third one?
The third one I'm going to take you to is the case of Grosvenor Chemicals. I can come to that in a moment. Can I just read Newson-Smith just for one moment, please? Page 454. And it is important in my respectful submission because, of course, we accept this is not Court of Appeal, but we do make the proposition that my learned friend says that the decision of Mrs. Justice Whipple in that case is good law, and indeed he's relied upon it at 2 points in his submissions. And you can see what's contained at paragraph 8. He cites it, and we respectfully agree. We have never contended that carelessness, mere carelessness, is going to be sufficient to establish a case in contempt. In other words, mere carelessness or negligence is on one hand and never been contended upon the applicants that can be. The other side of the line that Mrs. Justice Whipple refers to in paragraph 8 is recklessness in the making of a statement or other. Recklessness, sufficient mens rea for contempt. She cites Berry Piling with approval, and you'll see that at paragraph 8 of her judgment. So it is simply, in my respectful submission, wrong and inaccurate to say that Berry Piling is obiter simply because it's awkward as far as my friend's submissions are concerned, because we respectfully submit there is authority showing that this case is relied upon. So, taking, my Lord, the third of those cases, that's Grosvenor Chemicals, which is at page 494. The judgment starts at page 475, but it's paragraph 106, please. 494. In order for the allegation of contempt to succeed, there must be a deliberate or reckless breach of Rule 3122, by which I mean the relevant persons must have known that the document was subject to the rule and known that the acts complained of were in breach of that rule, or in either case were reckless in the sense of very piling. This first point puts together the factors in paragraphs 1 and 3 of the listing Tinkler. It's important, obviously, to understand that our primary submission is, of course, we don't need to, at a full hearing, it will be contended on behalf of the applicants, if they get that far, to say that this was intentional misleading by one or both of the respondents. So it's not our case is tied only to a recklessness case. I'm sure the court appreciates our primary position is one of intentionality. It is very much an alternative scenario, so that even if we can't show intentionality, we say recklessness is in the contempt proceeding sufficient and wholly distinguishable from carelessness or negligence. So that's the first thing that I wanted the court to be clear about in relation to our case. Secondly, my learned friend takes you to KJM, and there is one other reference that may be of some assistance in that decision in relation to what the test is for strong prima facie case, because in KJM, if you can go to page 86, please. The middle of paragraph 17, the question's been asked a number of times, understandably, from the court as to how do you draw the line between weak and strong. And of course, to what extent a strong case is going to be relevant on the question of the merits. But it is interesting to see how Lord Justice Moore-Bick puts it in the middle of 17. In my view, there is also a danger of reducing the usefulness of proceedings for contempt if they're pursued where the case is weak or the contempt is proved trivial. So it's another word, triviality, may be another way to see what is regarded as weak and to be distinguished from strong in the sense, we say, of not being, if you like, merely trivial. The significance of this is, and we say that specific cases don't really show what strong means, and we've both sides have tried to assist the court in its application, because each case is going to be fact specific, and a definition is needed rather than reverse engineered, if you don't mind the expression. And it's important, of course, to proceed and understand that all the submissions are on the basis of a hypothetical. There's simply no evidence as to whether the officers believed what they said to what the second respondent said to the court. She believed it or not. That's not really for the permission application to be determined. The learned friend assumes what the officers might say. We simply don't know at this stage. So that is why we can say that our case is not limited to the question of potentially of reckless disregard. May indeed be a question of intentionality. But my learned friend's suggesting that the idea that strong prima facie case should almost be an admitted situation. It is, in our respectful submission, far-fetched in the extreme to suggest that officers are going to admit voluntarily that they've lied to a court or that they've deliberately, consciously disregarded and made positive assertions to a court where they simply don't know what they're saying. And we don't, and I think the point is clear, we've never suggested that it's for, this is like a side avenue to try and criticise the police force. I think the court have this point. It's really about understanding what is contempt envisaged, both in terms of the obtaining of a warrant and the information contained in that regard. And coming really to my last couple of points, can I? You've been taken to what the first respondent said in his application. That was. Give me one moment. Page. It's. I think it was at page 210. 210. I'm very grateful. Thank you. In relation to paragraph 8, can I also remind the court first what's contained at page 212, where he says, at paragraph 16, I conducted an initial review of the investigation of 12th of March 2019 and concluded that it should proceed and that amongst other actions we should apply for a search warrant. So he has done conducted an initial review of the investigation before deciding that the search warrant should be applied for. And it's perhaps worth just reminding the court in relation to the concessions that were made on behalf of the respondent at page 401 in the judicial review proceedings. I know the court has this very much in mind, but at 22 and 23 set out a whole series of concessions, both in relation to the warrant and in the application form. I shan't trouble the court again, but you'll note 23.3, the application form referred to information from Companies House, but omitted to mention that there were registers of shareholders consistent with shares having been issued to investors. As far as wrongdoing is concerned, the defendant has conceded, and of course we have the judgment of Lord Justice Dingemans in relation to these proceedings, in relation to the contempt proceeding, that I think paragraph 2, sorry, that the arrest, in relation to the arrest proceedings, we can give the fire citation and provide the authority if needs be. It's at 2020.
I don't think we have the complete divisional court judgment.
We don't.
Rather remarkably. We have extracts from it in Mr Justice Kerr's judgment.
We do. It would probably be helpful for the court to have that. We can immediately provide that.
Yes.
Can I just...
I think we probably ought to see.
I think you should. Can I just say, in the citation, 2020 EWHC 3456 in the Administrative Court, Lord Justice Dingemans said at the beginning of the judgment, paragraph 2, in relation to the claim for damages against the Chief Constable of Essex, said this: "It is now common ground and should be stated at the outset that Mr and Mrs Norman were not guilty of the offences of fraud and money laundering for which they were arrested, and they were not prosecuted for those offences. They were and are persons of good character." So we have a concession on behalf of the respondent that they were essentially innocent people who should never have been subjected to this experience. I think that may be everything. I'm just checking. My lord, my ladies, thank you very much. There's nothing further.
Thank you all very much for your doctoral submissions. We will reserve judgment. We will send out a draft on the usual terms, which I'm sure counsel are familiar with, but for the avoidance of doubt, firstly, the decision is under embargo from general publication until the formal electronic hand-down, see the Counsel General for Wales's case. And secondly, we will invite submissions from counsel as to any typographical errors or similar obvious factual errors, not re-argument of the case, please. And if it's possible to agree the form of the order, including any matters as to costs, then well and good. If not, we will ask for concise written submissions on that topic. And mention of the word costs reminds me that I don't think we know what happened below. Did Mr Justice Kerr no order for costs, or did he make an order for costs one way or the other?
Costs were for the respondent. We received our costs.
Yes, right. Okay. Because we don't have the formal order for some reason. Thank you all very much for your assistance. If we could be sent the Divisional Court judgment, which isn't on Bailey, but
Leonard Junior will do that
Dos Santos
this
will do
afternoon.
it.
Yes, it should have been provided. It will.
Thank you very much indeed.
All rise.
Oh.